Does the $170,004.36 accurately reflect child support arrearage owed to Ms. Vu Johnson?
No, ma'am,
And why do you believe it does not accurately reflect child support arrears?
because I paid direct payments.
I am disputing all of that. I am
Okay.
disputing whatever. I'm sorry.
please don't interrupt.
Does he have a lawyer? Does he have a lawyer? What is he contesting? Like, what is the actual amount that you're contesting, Doug? Because, you know, whatever amount you're contesting does not pay back for the cars that we paid for, the housing that we put the kids in. So what exactly are you contesting?
You're asking me to suspend the law and make a ruling in this case, Ms. Hernandez. And I can't do that. There's a lot of issues in dispute here.
Could there have been a possibility that Ms. Vu thought that these payments were for other purposes besides child support?
Is he still a manager at his job?
Your Honor, objection relevancy.
But he had also asked my husband. Do you remember that, Doug? Where did that $900 come from? Where did that amount come from? Because the divorce decree on here says the
Ma'am,
Okay.
ma'am, this is not appropriate what you're doing right now.
I'm just trying to show a pattern of deceit and lies with this person. I was told recently that if he like got another job and he made more money, was he not supposed to report that? I don't know if that's true or not. Was he supposed to report that?
Mom is saying Dad owes $172,000 in child support arrears, but Dad is saying he paid $98,000 directly with checks.
This time, I would like to ask the court to take judicial notice of the motion to enter the Quadro, along with the attached exhibits, which include the final decree of divorce as states Exhibit A, and the payment record filed at the time of the pleading, which is marked as states Exhibit B. And particularly, I would like to ask the court to take judicial notice of the decree on page 19, which orders Mr. Doug Vu to pay current child support in the amount of $1,398.13 per month, starting September 1st, 2006, and also includes a step-down child support amount of $1,118.96 per month when there is only one child left, unemancipated.
I do take judicial notice of the pleading as well as the divorce decree and the payment record. Before we get too deep into this, I just want to make sure everyone is ready to proceed today. This is the first setting and it's only was filed last month. So I just want to make sure you're both ready to move forward. Mr. Vu?
Your Honor,
Mhm.
Your Honor, I wasn't aware that I couldn't dispute the amount in this setting, and that I would have to file a dispute. So I thought this would provide me the opportunity to dispute the amount, but Ms. Villarreal mentioned that it's not.
And Your Honor, yes, there are no pleadings regarding any confirmation of arrears. We are just here on the OAG's live pleading motion to enter the Quadro in this case.
I will let you all know though, if there is an arrears dispute, I am not going to order a Quadro, knowing that it might not be accurate, the pay record, for whatever reason. And so
I'm
if the
not
underlying,
understanding all these legal.
he's contesting that he owes what the AG says he owes, it sounds like.
Mhm. Okay.
And so, I mean, I don't know how much money is in the account. I don't know how much he's disputing, so that could affect me. I mean, if there's a small amount of money in the account and he's only disputing a small amount, then I would grant the Quadro. But if it's a sizable sum and he's disputing a sizable sum, I believe that issue needs to be addressed before a Quadro gets done, because I don't want to take money that's not owed from somebody's accounts.
Yes, ma'am. I sent Ms. Villarreal a couple of documents that are in the meeting chat. I don't know if you have access to those. Or
And Your Honor, at this time, I am going to object to any documents provided by Mr. Vu, since there are no live pleadings regarding the dispute of the arrearage at this time. I would believe at this point it would be outside of the scope of the pleadings that are before the court.
I don't, well, first of all, they haven't been admitted into evidence, and I'm not even sure what they are.
Your Honor, it's an affidavit of direct payment of $98,100, as well as there's incorrect amounts in the accounting. There are a couple of collections that aren't recorded in the accounting for a total of $9,296.22, ma'am.
Okay, Ms. Villarreal, even though
I am disputing all of that. I am
Okay.
disputing whatever. I'm sorry.
please
Is
don't
that,
interrupt.
does he have a lawyer? Does he have a lawyer,
Ma'am, I don't believe
or
he
is that
does.
him?
That is him.
Because
So
I don't recognize his
Ms.
voice
Vu.
at all.
Ms. Vu,
Ms. Vu,
first of all, you're interrupting. Second of all,
I'm sorry.
I'm thinking you need to either be on the app where you can see people or be live in court. Because it's very hard for people to have contested hearings on the telephone. Like you're frustrated because you can't see what's happening, but that's because you're not on Zoom. Mr. Vu can see what's happening because he's on the Zoom app, as can I. So I'm sorry that this is frustrating, but to participate fully, you may need to download the Zoom app.
I tried doing that on
Okay.
my iPhone, and I don't know how to do. I'm not technical, and it gave me. I took a screenshot to show that. So I went on and put on what is it? I followed the
Okay.
instructions, and it did not work for me. And so I was desperate, and I called in.
Okay, and that's
thinking
fine. I
that this
also
was,
think you can probably just Google Zoom without downloading the app and still get on like this. My children used to do that to get onto school sometimes. So I'm not
Okay,
sure you
can you
need the
give
app
him-
to fully participate. But I'm not a Zoom expert. I'm not the tech expert. I am the judge. So for one thing, so just be patient, especially since you can't see what's happening. I was going to let everyone know, since you are asking for money to pay these arrears, I believe you've put the arrears at issue. So what they are does matter because it would affect what, if anything, I would grant. But my initial question was, is everyone actually ready to proceed today? Do people need more time to get exhibits together? Does anyone want to hire a lawyer? I just want to make sure you're ready before we have a full-blown hearing.
Ma'am, I've got the
Mhm.
documents ready that I can share.
Ms. Vu, are you ready?
I mean, I am here. I am ready, but he's saying that he has documentation. All I know is that the divorce decree that that we agreed to, he had not followed through at all. So this is just about the child support,
Well,
or is this about
Ms.
all?
Villarreal, are you all ready to proceed today? Maybe you all need to
Mhm.
file a pleading to address the arrears,
and
unless you're all willing to trial amend.
Your Honor, at this time, the state is not going to try the dispute of the arrears by consent. So if
Okay.
Mr. Vu wants to file his own pleading, and we can reset this matter in the future so that he can get that done. But at this time, since there are no pleadings filed by Mr. Vu, state's not ready to proceed regarding his actual request for any direct payments or credit or anything like that, as far as what he is requesting Your Honor to consider.
Also, Your Honor, my oldest son, I took full custodial care of him starting in March.
Okay, ma'am, sir, that you're getting into the merits of the case, and we're not there yet. At this point, I guess I'll give you all more time to figure out how you all want to proceed. That includes
Can
you,
we do
Mr.
this?
Vu, you, Ms. Vu, and ma'am, can you please stop interrupting?
Yes, yes, ma'am.
And Ms. Villarreal as well. And we'll reset for everyone to see. Again, I don't know how much is in the account. I don't know how much this is an issue. But I am very hesitant to order quadros when arrears are in dispute.
Yes, Your Honor.
How much time do you want, Mr. Vu, to review to file pleadings? I do need a pleading before me to address the arrears if they are being contested. I can't
Yes, Your
tell
Honor.
people what to file.
I understand.
Judge, at this, I'm sorry, go ahead, Mr. Vu.
I was going to ask for 2 months so I can figure out how to handle this.
Okay. And Ms. Vu, did you have something you wanted to say?
2 months. I'm trying to raise my hand. I'm like, what is he contesting? Like, what is the actual amount that you're contesting, Doug? Because, whatever amount you're contesting does not pay back for the cars that we paid for, the housing that we put the kids in, the educational loan that we took out. So what exactly are you contesting?
Okay, ma'am, that's not being addressed in court right now. You all can discuss that offline, but right now, that's not before me yet.
We do have January 8th as well, Judge.
Okay, why don't we do January 8th?
Okay. And 8:30 or 11, can we do 11:30, Judge, on this one?
It's likely to be contested, so I think we should do 8:30.
Okay, that's
We
fine.
might need a big old hearing.
Yes, Judge.
Your Honor, so the January 8th reset, is this for the Quadro again, or is this for the pleading?
I can only entertain what is before me and what is filed with the court. Right now, all that's before me is the Quadro. You all are free to file anything you want. I don't want to limit you to just one pleading. So if other pleadings get filed by anybody in this case, and it's properly filed and noticed to everybody, it can be addressed at that hearing. But
Yes,
it needs
ma'am.
to be filed by somebody to be addressed, whatever the pleading is.
Thank you, Your Honor. May the parties be excused back to their breakout rooms. I can prepare a reset order and send them to them so they can sign.
Yes, you may be excused back to your breakout rooms.
Thank you.
And yes, you're both free to consult. Well, the AG doesn't represent either of you, so you are both free to consult lawyers if you wish, or talk more to the AG about this issue. Okay,
Thank you, Your Honor.
okay, thank you. This appears to be a motion for a qualified domestic relations order. Last time this was before me, I believe there was a contest of arrears.
Yes, Your Honor. Neither party obtained an attorney, so I'm here to ask that the Quadro be entered and signed. I will call each party to state their reasons, yes or no, and then ask that it be signed.
Okay, I expressed concern at the last hearing about entering a Quadro while there's an arrears dispute. I don't know why the Attorney General, is there an agreement to trial amend and address
No.
disputes?
No, there is no agreement to amend. There's no agreement to anything, and neither party has filed a petition, counter petition. Neither party's filed for possession credits or submitted receipts for direct payments. And I do understand you asked parties to contact attorneys, but neither one or Mr. Vu we don't have that. I have no agreement.
Mhm.
All I have is the amount approved by Chevron Corporation in the Quadro.
I'm confused as to why the Attorney General's office didn't file a pleading, because this is the core issue of child support.
I understand. I agree. I agree. But I'm not sure why there was no motion to confirm filed prior to this.
Okay, and I've seen cases where Quadros are filed, arrears disputes come up, and then the Quadro gets kind of put aside until the arrears get resolved.
Right. No, I understand.
No, okay, but proceed. I mean, you might have testimony that changes my mind. But in general,
understood.
as a general matter, I don't like ordering money. I don't like taking moving money that can't get put back in the bag if it needs to get put back in the bag. I'd rather have
Understood.
zero before extreme enforcement remedies are taken.
Yes, no, I completely understand, Your Honor. And I am surprised there is no other pleading on file today as well. So,
Your Honor, if I could, I'm sorry, Your Honor, if I could speak.
Very briefly, because I believe I understand what's going on and testimony at this point can be taken, but you may speak, Mr. Vu, briefly.
Yeah, I tried to get an attorney to review the case, and the amount they were going to charge me as a retainer was just so exorbitant that, given the risk, that's why. But I filed all the paperwork to the Attorney General to ask for relief, and I just never got a.
This is hard to explain to lay people. That there's different organizations, for lack of a better word. I'm with the court, and the court paperwork gets filed through the district clerk's office. The Attorney General's office is an agency that works with people to manage child support, but filing paperwork with the Attorney General's office does not automatically mean a pleading gets filed with the court. And I only address issues filed with the court. I don't get to address issues filed with the Attorney General's office. And that applies to both of you and anybody watching on YouTube. The Attorney General's office can administratively handle things, but once you're in the courthouse, I can't administratively handle things. I handle what gets filed judicially. You may proceed, Ms. Hernandez.
As on this record, as you can see, as of August 31st, 2023, it states the amount of child support arrears is $170,000, $170,004.36. Does this accurately reflect the amount of child support arrears owed to you?
I believe so.
Did Mr. Vu give you child support cash to you in your hand or otherwise, which would make this amount lower?
No.
Are you asking the court to enter the qualified domestic relations order for the amount of $170,004.36?
Yes.
Mr. Boo, as shown on the screen, as of October 31st, 23, does the $170,004.36 accurately reflect child support arrearage owed to Ms. Vu Johnson?
No, ma'am.
And why do you believe it does not accurately reflect child support arrears?
Because I paid direct payments starting from, I want to make sure I give you the correct date, October 2008 in the amount of 900, all the way through to March 2017 when the OAG filed the wage garnishment.
What
So
amount
total-
did you say? You said the
But,
amount, I can't remember the number. Was it 800?
900, ma'am.
900.
how did you allegedly make these payments?
I paid it as a check payment every month that my son would provide her. I've got a couple of stubs. One of the things I've been trying to do is I've been trying to contact my bank to go all the way back to get copies of the stubs, but they haven't. They're telling me unless I file a motion, they won't grant that because it just goes too far back. But I have examples when it first started.
Well, do you have copies of how many payments are you saying you made? 100? Did you make 40? How many exact payments did you make?
Yes, ma'am. So 91,800 divided by 900. Let me do the math real quick. 102 payments, ma'am.
All right. So are you saying that somewhere you have or can obtain 102 canceled checks for $900 each?
Ma'am, I don't have physical copies of 102. I have a couple of examples that I kept, and I tried to get the bank to provide me more, but they weren't able to. I can upload a few examples if you'd like.
Well, I've my next question, sir, is have you contacted your pension company, Chevron Corporation, to discuss this with them?
Yes, and what they've said is it's up to what the Quadro says, what the outcome of
right.
the Quadro is.
All right. Nothing further past this witness.
Your Honor, I'd also like to see if I could get if there's any way I could get credit for the fact that my oldest son lived with me since 2011.
May I call Ms. Johnson, Your Honor?
Did you hear his last statement, Ms. Hernandez?
He's saying that one of the children lived with him. So I'd like to ask Ms. Johnson if this is accurate, or, you know.
Okay, you may do
No,
so.
Your Honor, that is not accurate.
Ms. Johnson, okay, so did you relinquish custody of one of your sons to Mr. Vu for an extended time, longer than 6 months?
Yes, for longer than 6. After Hurricane Ike, when we were going through construction here, he did stay with Doug, but he was a latchkey kid. And then before he graduated, before he finished high school, he was kicked out of his father's house, and that caused us to find Nathan a place to live. I talked to the counselor, his school counselor, and told them the situation. He was at risk of not graduating. And that's when I went to the state to complain and let them know that he had been paying his child support. The only evidence that I have is the only evidence I have is the divorce decree, the original divorce decree, where I followed everything to the T. He did not. I kept my kids insured. I took them to all their doctor's appointments. I provided him with all our information. He denied me his information. When he left his employment, he didn't notify me. He didn't give me his change of address, any of that stuff. Everything here, everything, the original divorce decree, I followed. I did the for kids' sake class. He did not. I've kept my kids out of the loop of our legal matters. up until recently. They're
All
old
right,
enough now
and
to make up their own.
And when you say your son went to stay with Mr. Vu, was that because of Hurricane Ike damage to the home or something?
Yes, ma'am. Yes, ma'am. And to this day, we're still making repairs, but it
Okay.
was within
Okay,
that
y'all-
period where
Okay.
we had no.
Objection? Okay.
Sustained. Okay, everyone, I'm concerned. Okay.
Judge, I
No,
have,
no, I'm talking. I'm just getting my thoughts together. You're asking me to suspend the law and make a ruling in this case, Ms. Hernandez. And I can't do that. There's a lot of issues in dispute here, and they're not really pled before me. So whether I rule in Mr. Vu's favor or Ms. Johnson's favor or somewhere in between, there's no ruling to be made because there's no trial amendment agreeing to, I mean, I could say you're consenting to hear this case because you're proceeding, you're both proceeding. I'm not
Right.
sure where you're all going with this though. I'm not sure this case is ready for a hearing. There's a lot of issues here that are like out there but not being addressed.
Understood.
People aren't agreeing to proceed, but they're proceeding. I think there's confusion, and I'm not sure what's being asked of me because I don't get to just say, well, I feel like it's more fair we do X, so we're going to do X, but that's
Right.
appealable. It's not proper. And
I
so
understand, Your Honor.
no matter
and,
who I rule for, the other side is going to appeal this because it's not proper.
Right. May I, sua sponte, make a motion for continuance because, as you know, the Quadro amount can't be changed anyway. So, may I do a motion for continuance to review this with, managing counsel and if there's another avenue to proceed at this time?
Yes, I'll grant one more continuance to get this right. And this will give everyone a chance again to get evidence. My ruling should be based on evidence and proof. And if you all have proof, please get it to the Attorney General's office so it can be shared in court. If you need to file pleadings with the court, they get filed through the district clerk's office.
excuse me, Ms. Hernandez, I did send an email to Ms. Villarreal, the last Attorney General that was on the case. I didn't get a response back from her. So who do I contact at the OAG?
I'll give both of y'all the general service email address in a moment. You're on, let me get a date. Are both parties available February 28th? It's a Wednesday.
I mean, I don't understand why this keeps getting pushed off. Like,
Okay, Ms.
what am I
Johnson,
supposed
I
to?
can speak with you afterwards. I'm just getting a date. Are you available 2/28 on Zoom?
Yes, ma'am.
Okay, do you want Your Honor, 2/28 at 8:30, please?
Okay, we'll reset
and-
it for February 28th at 8:30.
It'll be, thank you. Final setting, and if both parties could go into their rooms, and I'll speak with them and give them a service email address.
Okay, so I guess, ma'am, can you answer Ms. Villarreal's question? Are you having any witnesses?
I do not have witnesses today.
Okay, are you requesting anything of the court?
I'm requesting if you received a copy of the original divorce decree in full, because last time you had partial.
Yes, the full divorce decree has been uploaded into Odyssey, the county system. So the county has a full copy of the divorce decree.
Okay, thank you.
Okay, so are you ready to proceed, ma'am?
Yes.
Okay. Ms. Villarreal, you may call your first witness.
Thank you, Judge. Judge, before that, I would like to ask the court to take judicial notice of the motion to confirm support arrearage that was filed with this court on February 1st, 2024, along with the attached payment record listed as that was listed with the pleading as States Exhibit B and the divorce decree that was listed as States Exhibit A. Specifically, the divorce decree, I'm asking that the court take judicial notice that on page 19 of that decree, current child support is $1,398.13 per month for the support of 2 children. I'm also asking the court to take judicial notice of the step down provision listed on page 20, with the child support obligation being $1,118.96 per month. And I'm also asking the court to take judicial notice of the page 21 of the divorce decree that indicates that all payments should have been made through the state disbursement unit, along at the state disbursement unit address listed on that decree.
I take judicial notice of your pleading as well as the attachments, the portions of the divorce decree that were attached to your pleading that do recite what you just stated, as well as the pay record that is attached to your pleading.
Thank you. And just another housekeeping matter, the state also did file the motion for entry of a quadro, and that was filed on September 13, 2023, and that is reflected on the court's file for this case. At this time, the state is requesting that the motion for entry of quadro be reset for another time so that the issue regarding the confirmation of the arrears be presented before your honor and rendered today so that we have an amount as far as the confirmation of the arrears. And with that, Judge, I would like to call Mr. Vu. How old are they now?
2024 and 22.
Now, what is the name of the mother?
Lauren Vu Johnson.
And you and Ms. Vu were divorced, is that correct?
Yes, ma'am.
Okay. And both of you signed a final decree of divorce.
Yes, ma'am.
And in that decree of divorce, who was ordered to pay current child support for the children?
I was.
Okay. And who was designated as the conservator who had the children?
She was.
Okay. Now, your obligation per month for 2 children was $1,398.13. Is that correct?
Correct.
Okay. Now, sir, was there ever a time where you made child support payments directly to Ms. Johnson?
Yes, ma'am.
Okay. And in fact, how would you make those payments to her?
It was through a personal check that I provided every time I dropped off and picked up the kids once per month.
And in fact, you have copies of a few checks regarding those payments. Is that right?
Yes, ma'am.
Okay. Now, do you understand why we're here today? Is that right, sir?
Yes, ma'am. And the reason why I can't, if I can expand, the reason why
Okay.
I can't.
At this time, let me ask you the questions and then you can just answer them, okay?
Understand.
At this time, there are alleged arrears on this case, correct?
Correct.
And that's for failure to pay the child support obligations.
I did not pay them directly to the disbursement unit, correct?
Okay. Now, you understand that the Office of the Attorney General is involved in the suit, correct?
Yes, ma'am.
And there was a payment record regarding all of the payments or failed payments on this case, correct?
Correct.
Okay. And Judge, at this time, I would like to offer State's Exhibit B, which is the financial activity report associated to this child support case. As of yesterday, when this document was generated, it shows that you owe a child support arrears balance of $167,420.68. Is that correct? According to this document.
According to the document, yes.
Okay. Now, recently, you have been making payments through the state disbursement unit since on or about 2017. Is that correct?
March 2017, correct.
Okay. Now, you are disputing the amount because you are asking for credit of the direct payments you've made to Ms. Vu.
Correct, as well as the possession credit for my son.
In addition, you are asking the court for possession credit, correct?
Yes, ma'am.
Now, let's get into the direct payments. So you were able to provide some checks that you wrote to Ms. Vu, is that correct?
Yes, ma'am.
Okay. Now, Judge, at this time, I would like to offer non-custodial parent, Mr. Vu's Exhibit 1, which is a copy of the 8 checks that were written by him. I'd like to offer that into evidence.
Does anyone have any objection to me admitting his NCP's Exhibit 1 into evidence?
I don't agree with it.
Do you have a
So,
legal objection?
so do I say like I object to what he's entering, or
I can't give you
I'm
legal
not agreeing
advice,
to?
ma'am. This is
I'm
your
not
chance
agreeing.
to make your legal objection.
Sorry, what?
I cannot give you legal advice. This is your chance, or the state's chance, to make any legal objection they have with regard to admitting this document into evidence.
I'm objecting that it's not truthful.
Okay. Ms. Villarreal, do you have any legal objections?
No, Judge, I'm offering the exhibit, so no
Okay.
objection.
I'm going to
Okay.
admit it as NCP's Exhibit 1.
Thank you. And Mr. Vu, the first check, when was it written?
Let me make sure I give you the correct date. The first check was written for October 2008 in the amount of $900.
Okay. Now, the second check that I'm showing, it was written November 20th of 2008, correct?
Correct.
And it was in the amount of $900.
Yes, ma'am.
Okay. The third check that was written was December 20th of 2008 in the amount of 900. Is that correct?
Yes, ma'am.
Fourth check is January 20th of 2009 in the amount of 900.
Yes, ma'am.
Fifth check, December 1st, 2016, the amount of
Yes.
900.
It wasn't the next check that was paid. It was, these are only this is only the checks that I can get from the system because they're only obligated to hold 7 years back.
Okay.
I wasn't able to retrieve it all.
Now, and the checks that are shown here, this is a check from January 1st, 2017 in the amount of 900.
Yes, ma'am.
And then February 1st, 2017 in the amount of 900.
Yes, ma'am.
And the last check shown here is March 1st, 2017 in the amount of 900.
Yes, ma'am. And then after that, the state did the garnishments.
Okay. And that's when you started paying through the state disbursement unit.
Yes, ma'am.
Okay. So you have, as an exhibit, 8 checks in the amount of $900 to prove that you paid that directly.
Yes, ma'am.
Now, was the intention for these checks to be paid for child support specifically?
Yes, ma'am. And I recognize that it was for whatever the difference of $1398 minus 900, and I recognize those are arrears that I do owe the difference.
Okay. Do you know, only if you know, do you know if Ms. Vu was aware that your intention was to pay the child support with these checks?
Yes, ma'am. As they were written on under the memo statements, and they were accepted every month.
How did you express your intention that these checks were specifically for child support?
At the time when I started to make the child support, those direct payments in March of 2008, we had a conversation, and I said I will owe you the arrears once I get back on my feet from the failed business, and so that's what was discussed, and I did it directly, and that's what we concluded.
Now, when was this conversation had?
To be honest, I don't remember the exact date, but they were accepted for over 7-9 years. I don't recall the exact date.
Now, I'm not talking, so let me clarify. I'm not talking about the acceptance of the check. My question to you is, how did you communicate to Ms. Vu that these checks were for child support?
Through conversations.
Okay. And how did you have these conversations? What manner?
Through a variety of manners, direct conversations in person. I tried to go find an email, but I couldn't find any emails that went back that far.
Could there have been a possibility that Ms. Vu thought that these payments were for other purposes besides child support?
I don't think a reasonable person seeing the checks and the memos as they're stated would have any misunderstanding of what the intent of those checks are for.
Now, Mr. Vu, were you responsible for paying anything else to Ms. Vu outside of child support?
There was a house for which at the time we both agreed that we would do 50% upon the sale of the house, but unfortunately the house went into foreclosure. Now the foreclosure, both had an opportunity to try to take the house and take it out of foreclosure, but I had lost everything, so I could not, and I guess she did not either.
Okay, so my question to you, Mr. Vu, is did you have any other obligations besides the child support to pay to Ms. Vu?
No, ma'am.
Okay. Now, sir, you mentioned that there was a time that you had your oldest residing with you. Is that correct?
Yes, ma'am.
And this was previously mentioned before, correct?
Yes.
And what was the time period of when your oldest child resided with you?
He began living with me from March 2011 to May 2017, after May 2017, but essentially
I'm
until
sorry,
he
March
met.
2011, you said?
Yes, ma'am.
When saying dates, can people speak slowly? Because it's very hard to listen, hear a lot of numbers and try to write them down, because this is going to be a lengthy hearing and I'm not remember.
I understand.
So March 2011 to what?
May until he emancipated, and then he lived shortly
And
after
when was that?
with
When did
May
he emancipate?
Actually, I don't know the exact date, but roughly May 2017.
You understand that you still had an obligation to support, even if it was just one child, based on
Yes,
the
ma'am.
decree, correct?
I understand.
And in that decree, which the judge already took judicial notice of, that step down, your support obligation was $1,118.96 just for the one child. You understand
ma'am.
that?
Yes, ma'am.
So, and you understand that the difference between the child support amount for two children as opposed to just supporting one is $279.17 per month, correct?
Yes, ma'am.
Judge, at this time, I would like to offer State's Exhibit D, which is a proposed possession credit calculator based on the time frame of March 2011 through May 2017. And I'd like to offer that into evidence as State's Exhibit D as a guide to help the court.
Ma'am, do you have any objection to me admitting this as an aid to the court?
I don't agree with it, but I mean, he did have our son.
Ma'am,
from-
right now we're just talking about admissibility.
Oh,
Do you have
okay.
any legal
Yeah, please
objection?
admit it because I want to debunk it.
Okay. I mean, if both of you can refrain from commentary and just stick to answering questions, I would appreciate that. It's really not proper for either of you to do that.
This shows the total principal amount based on the $279.17 per month, correct?
Correct.
Okay, now you understand that that amount did accrue interest throughout the years.
Correct.
Okay, and so the total maximum credit for possession would be the $33,186.78. You understand that?
Yes, ma'am.
Based on this amortization calculation for the difference, correct?
I understand.
And you're asking the court to award you the possession credit of this amount.
Yes, ma'am.
Okay. Judge, at this time, I would like to pass this witness subject to any rebuttal.
Ms. Vu, do you have any questions for Mr. Vu to answer in the form of a question?
Yes, he says that Nathan stayed with him until May. That is a lie.
Ma'am, that's not a question. This
Oh,
is question. This is if you have a question you want to direct towards Mr. Vu for Mr. Vu to answer.
I have many questions.
Okay, this is your chance to ask them, ma'am.
What makes you think that you can admit that as evidence when you know the truth? Like, you can ask the counselor why I went and reported you. You kicked our son out. Why would you knowingly
Your
lie
Honor,
to
I
the court?
object relevancy. it's already been stipulated from the last hearing. She acknowledged that my son stayed with me. We can go back to the record to have that.
Sir, I'm
And
gonna,
Judge,
yes,
and state's gonna object to compound. If she could just break down her question.
I'm gonna overrule Mr. Vu's objection, but I'm gonna grant Ms. Villarreal's objection because I'm not sure what you're asking. If you can ask one question at a time, ma'am.
When did Nathan officially move out of your place?
I do not know.
Why did he move out of your place?
Ma'am, one question at a time.
I do not know the exact date, but it was somewhere in the middle of 2017.
Have you spoken to the counselor?
Objection time frame.
Ma'am, what time frame would you speak to the counselor?
Has the state received? I know I sent a email. Unfortunately, it was today from the person that Nathan was staying with back in December because we had to find housing for him.
Ma'am, this is not your chance to just talk. And when you ask questions, you often use it as a chance to get your information in, and that's not proper. So if you can stick with just asking factual questions without commentary.
I've never done this before, so I don't know what I'm supposed to do. I'm just here to answer questions, and what I'm saying is I'm stating that the statements that he's saying are false.
This is your chance, ma'am, to ask questions.
And I'm sorry, I'm nervous to ask him.
You're going to get a chance to talk yourself later, and you're going to be given a chance to be asked questions by the Assistant Attorney General.
Okay, I honestly don't want to ask him anything. Okay, I don't want to ask him anything.
Okay, I just want to make sure it's clear for the record that this is you can have other chances too, but this is your chance to ask him questions if you have any for him to answer.
Okay,
regarding the issues before me, regarding the issues in this case.
Okay.
This isn't a chance to just talk. If you want to do that, I can send you to a breakout room or you all can talk offline. But this is this hearing is about the issues before me that are pled for, and this is the chance for both of you to present evidence and testimony regarding this case.
I mean, I do have questions for him because I'm like, is he still a manager at his job?
Your Honor, objection relevancy.
We're discussing arrears.
No, because
ma'am, I'm going to overrule the objection.
Yes, I'm still employed at Chevron.
Okay. So your paper keeping, your records, you're trying to say that you paid me all those checks, but yet you've been a manager on LinkedIn. I pulled this up. Matt pulled this up. You've been a manager. Let's see. You've been a director of a company. You've been a manager.
Objection, Your Honor. Objection, Your Honor. There's no question posed to the witness.
Ma'am, yeah, sustained. Ma'am, this is questioned.
Okay.
Ms. Villarreal, you may call your next witness.
Thank you. I'd like to call Ms. Lauren Vu. What is your relationship to the two children in this suit?
I am the mother of the two boys, Nathan and Matthew.
Thank you.
Custodial care.
Thank you. Now, Mr. Vu was court ordered to pay child support in the divorce decree. Is that correct?
Yes, ma'am.
Okay. Now, his obligation was a monthly obligation. Is that right?
Yes, ma'am.
Now, you heard, you saw State's Exhibit B shows that as of yesterday, Mr. Vu is in arrears for child support. Is that right? He owes.
Yes. The amount on the screen says $167,420.68. On this piece of paper that was sent in the mail says $168,000.
I'm going to object to the witness testifying to a document not admitted into evidence. The exhibit has already been admitted, Judge. An updated amount.
I'm going to sustain the objection.
Now, Ms. Vu, you could just answer my questions, okay? You heard Mr. Vu state that he paid you directly for child support, right? You heard him say that?
Yes, I heard him. Say it.
Now, and you saw the checks, the 8 checks in the amount of $900 that were admitted into evidence, correct? You saw them?
I saw what was on the screen, yes.
Now, ma'am, was there ever an agreement between you and Mr. Vu that he would pay you directly for child support?
No, ma'am. No, no, ma'am.
Now, those checks were in the amount of $900. Is that right?
I saw, yes.
Now, ma'am, did Mr. Vu have any other obligation to pay you a $900 per month amount for anything else other than child support?
Per month? No, he did borrow a loan, a business loan for, he called it a business loan, but he had also needed my co-signature for the beach house that we shared.
Okay.
So him,
So give me 1 second, okay, Miss Vu. So now you mentioned a business loan. Who provided? Was there a business loan taken out?
it's from my, he did. Doug Vu took out a business loan, but he also, because he's run up his credit, I don't know what the reason was, but he had also asked my husband. Do you remember that, Doug?
Okay,
My
Miss
husband
Vu,
for a loan.
if you could just
Yes.
answer my questions and you're not
Okay.
addressing your comments to Mr. Vu. Now, did he borrow money from you?
He did.
Okay. What was the amount of money that he borrowed?
25,000
Now, when did he borrow this money?
before. God, my husband would know because he borrowed it from my husband, and so that's why it's a joke.
Your Honor, objection foundation. For lack of evidence.
Overruled, but I will say, Ms. Villarreal, I'm not following a lot of
Yes,
this.
Judge.
But that's.
Now, how was Mr. Vu supposed to pay back the $25,000 loan?
He said that he was going to pay us when he could, and so he paid $900 a few times. You'd have to talk to my husband. That's why I needed him to be a witness. But every time I tried to bring him here, he got shot down because it was him.
Okay.
It was Matt. It was my husband.
Ma'am,
Matt
let me stop this for a moment. I'm confused because we started this case fresh today and you were asked if you have any
Yes.
witnesses. And you said no. No one shot you down or anything.
Okay.
I'm not sure what to do with this information.
Judge, well, I can continue to ask
Okay.
more questions from this party and see what other information she may know.
Your Honor,
Your
Honor, I object
then I will
again.
move on.
Your Honor, I object again. Foundation. This lacks any authentication whatsoever.
Okay. My objection too. I have objection too. Where did that $900 come from? Where did that amount come from? Because the divorce decree on here says the amount.
Ma'am, this is not appropriate what you're doing right now. So please calm down, take a deep breath. If you need to pause and take a break, we can take a break. But we can't just be yelling in court. And so I'm going to overrule his objection, and I'm going to hear more testimony on this. Be aware, I'm the trier of fact. I'm supposed to evaluate what I hear and receive and make my best judgment based on that. I'm trying to do that.
And just if you could just answer my questions, were you involved in this loan transaction?
Sorry, which transaction?
Was I involved in
The
this?
loan
The
transaction.
loan, okay.
No, I wasn't.
Were you aware that the $900 that Mr. Vu was providing to you were for child support payments?
No, ma'am.
Did Mr. Vu pay you anything directly for child support?
No, ma'am. No.
Now, your oldest child, Nathaniel, did reside with Mr. Vu for a period of time. Is that correct?
Yes, ma'am.
And what was that time period that he resided with him?
It was March in 2011 because we were under construction at our house after Hurricane Ike.
Okay. And when did, until when?
November, so Thanksgiving, the holiday break. And so my brother was the one that came and grabbed Nathan, and he was the one that informed me that he got kicked out of his dad's house.
Okay. Of which year?
16.
Okay, 2016, the
2016.
year before Nathaniel graduated.
Yes,
That was November 2016?
November 2016. Because
Okay.
I came to the OAG's office in 2017.
There was a calculation for possession credit for the time period of March 2011, ending in December 2016. You saw that, right? As the exhibit?
I saw that.
Okay.
And I didn't agree with December because, that was giving him more credit.
Understood. Now, at this time, I would like to offer State's Exhibit E, which is the calculation of possession credit for the time period of March 2011 through December 2016. Now, you understand that this is an amortization calculation, correct? So it includes the calculation of the interest that was accrued as well. You understand that?
Yes, sir.
Okay. Now, it starts March of 2011, okay? And this calculation includes the actual principal amount per month, which was the $279.17 difference per month, correct? Now, and it also calculates the interest rate that was accrued for each specific month. Do you understand that?
Understand.
And according to this calculation, based on the time frame, which is all the way through December 2016, the maximum credit is $31,218.61. Do you see that number there?
I see the number. Yeah.
Okay. Now, but your testimony is that he should not be giving credit of this December 2016.
No,
Correct?
ma'am.
Because he did not, Nathaniel
He
did
did
not
not.
reside with Mr. Vu during that period. Okay.
Correct.
Now, so that would be that we should subtract the $397.82 from the actual total maximum credit, this $31,218.61. Correct?
Correct.
And that Mr. Vu would be entitled to possession credit for that time frame of March 2011 through November 2016. Correct?
Correct. But I'm oh, I'm sorry.
It's okay. Go ahead.
Okay. But I'm arguing that I took care of the children with all their medical needs, everything that they needed. And so that's why I'm like, I don't think that he deserves the relief or any of that credit.
Now,
but I mean,
Ms.
that's what's the court to decide. But I mean, Nathan did live with him. Nathan did live with him from March till November. I do agree with that. But giving him the, that to me, I don't agree with.
Okay. Now, Ms. Vu, let me ask you this. So from March 2011 through November 2016, what type of support did you have to provide for Nathaniel during that period?
My husband kept full insurance on the children. Anything that they needed, I provided. We provided for his brother as well as him.
Now,
But
as
it was
Your Honor, objection foundation. We're solely discussing the issue of my oldest son, not my youngest son, which I never disputed that he lived with her.
I'm going to sustain and let you just answer the question, ma'am. You tend to go beyond what's being asked,
okay.
and you really need to stick to what's being asked. So I'm going to sustain the objection, but give you a chance to re-answer, just answering the question.
Now, ma'am, what other supplies from the time period of March 2011 through November 2016 did you have to provide for Nathaniel while he was residing with his father?
We had gotten several phone calls from a neighbor when he lived at the apartment, the Millennium. The neighbor had called me directly and I had came.
Objection, Your Honor, hearsay.
An objection, Your Honor, non-responsive.
I'm going to sustain both objections. I also don't know what that even is.
When he needed money.
Hold on, Ms. Vu.
Yep.
The objection was sustained, so let me ask my question again, okay? Did you have to provide any additional supplies for Nathaniel during the time period that he resided with his father?
No.
Okay.
I guess.
And who provided?
I don't understand what you're asking.
Okay, wait for my question. Who provided Nathaniel with school supplies during the time that he resided with his father?
I did. When he came here, there was a box of supplies that he went through. So I don't know if his dad probably supplied some, but I'm 100% certain he came here and I provided the backpack. I provided, Matt provided him with a laptop and whatever supplies that we had here. Whenever he needed something, when he came for a visit, he had access to whatever we had. 'Cause
Now,
his dad was traveling. His dad was traveling. And you cannot deny that. He was traveling a lot.
okay. Now, Ms. Vu, so what additional expenses did you have to make during the time period that Nathaniel was living with his father?
And that was it.
I'm sorry?
That was it.
Just the school supplies?
School supplies. We maintained the health insurance if they asked for it. I remember I took him to the optometrist and the dentist when he was
Your
here.
Honor, again,
And
objection, hearsay.
And Your Honor, I'm
I've
gonna,
already,
and Judge, I am gonna object to relevance solely on the purpose that the motion for confirmation is just for child support and not any outstanding medical support obligation or any uninsured medical support expenses. None of that was pled for or asked for in the OAG's pleading, Judge. This is solely just for the child support.
I'm going to sustain the objection.
Okay. Judge, at this time, I pass this witness.
Mr. Vu, do you have any questions of Ms. Johnson for her to answer?
I'm almost afraid to answer because this will just get out of hand, or ask because this will get out of hand, Your Honor. I just want to be able to enter some proof of.
Okay, this is not that time. So let's get past my first question before we go on to other things. Do you want to ask her anything?
No, ma'am.
Okay. Do you have anything further, Ms. Villarreal?
No, Judge.
Okay. Since you're both representing yourselves, I'm going to give you both a chance to say anything else you'd like to say. The state does not represent either of you. I don't represent anybody in this. I'm here to listen to evidence, a ruling. So I'm going to let you speak. I just want to remind you all, this is court. Please follow court decorum as you would in a courthouse, even though you're on a computer. This is a courtroom. And please remember to stick to the issues that are before us, which is a confirmation of arrears. Mr. Vu, I'll let you go first.
Well, yeah, Your Honor, I just want to just acknowledge the evidence that I put forward. I just want to acknowledge that there are arrears that I did owe, but they are not the amounts. I want to acknowledge that we've accepted the possession credit. I want to acknowledge that the reasonableness clause to be able to state that, given those payments that I made that clearly show they were intended for child support payments, and the fact that they were accepted by her acknowledges those were child support payments. I would acknowledge that. That's it, Your Honor. That's it. Thank you.
Thank you. Ms. Johnson, is there anything else you'd like to say?
I want to say that what he has, it says on there that that he put into evidence back in 2017. He had all this time to prove that he paid me those. That was 2017 when I went to report him. He had all this time. Where is the evidence? The last OAG's lawyer said that he had to provide 104 checks. Where's that proof? I don't know how am I supposed to defend something that doesn't exist? I'm just trying to show a pattern of deceit and lies with this person. I was told recently that if I just found out, I didn't know, but if he like got another job and he made more money, was he not supposed to report that? I don't know if that's true or not. Was he supposed to report that? Can the court answer that to me?
I cannot answer that question, ma'am. It's not relevant to this proceeding. I'm not here to just answer. I can't give legal advice, and it's not my place, especially something that is not relevant to this current proceeding before me. It's inappropriate for me to be advising you.
Okay, well, what I'm stating is that he's been hiding assets ever since we divorced. When we were together, he was hiding assets, and after he was hiding assets, he had another restaurant called Cafe Madrid. If you look it up, you can't find it. But if you go online and you put in Cafe Madrid, because I just found it, I went scouring the internet for it. I couldn't find it, but then when I scoured the internet and put in key information because he was in the paper.
Your Honor, at this time, I am going to object to to relevance and narrative.
Well, it's a pattern. It's a pattern. And he was supposed to report his earnings or his job, correct? Like if he was to get another job.
Judge, may I get a ruling on my objection?
I'm going to sustain the objection. Please try to stick to relevant issues. Actually, and what time frame are you talking about before I make that? I'm going to possibly amend my ruling. What time frame are you talking about with this restaurant? Because you got divorced back in like 2005, if I'm not, or 2010.
2010. Do you 2000? I think the restaurant
2006.
was,
It was 2006. It was September of 2006. It's an 05 clause number. So that's a long time ago. So what time are you talking about this restaurant?
he had a restaurant called Cafe Madrid, and I believe it was 2008.
Okay,
It was
so are you
2008.
claiming there's assets from your divorce that weren't divided?
Yes, there was assets
Okay.
that weren't divided.
Ma'am, okay, I'm not, at the risk of stepping onto legal advice, I just want to let you both know, this is not a litigation. No one has filed to address assets that were not addressed during the divorce. There are legal avenues, and remember, I told both of you last time, you might want to consult lawyers because it sounded like there's a lot going on. And this ruling that I do today won't prevent you from still doing that. However, I'm not here to open up your divorce and relitigate issues that might not have been addressed. That's not before me. And I'm also not here to address any unreimbursed medical that's not before me. Those issues are things that can be filed separately. So it's not something you get to offset because it's a completely different legal claim. There are things that offset things, and there are, possibly reasons to offset things. But I'm just going to let you both know those are separate legal actions that you're referring to. You may continue.
So I mean, I'm here because of the Quadro, and I agreed with the Quadro. And so the other stuff that he brought before the court, I don't agree with.
At risk of opening Pandora's box, I have a few questions. When was the loan made to Mr. Vu?
It was made. Can I ask my husband?
No. Was it after
Because
the divorce? Before the divorce?
He came to Matt. He came to my husband and asked my husband.
Was this after your divorce?
Yes. No, I mean, this was like when we were in the middle of,
Your Honor,
we were separated.
objection foundation.
We were
I'm
separated.
asking a question. I'm asking for the date. I don't know when. I'm asking when this loan was
I don't
made.
have the exact date, and I don't want to purge myself.
Okay. Was it? Do you remember if it was before the divorce or after the divorce?
It was during.
During the divorce?
It was during our separation.
Okay.
Because
Your Honor, again, I'm objecting
it was
foundation.
very contentious.
I'm overruling the objection.
It was contentious. It was contentious. I was kicked out of my beach house when we were living at the beach.
That is not what I asked. I'm asking the dates, approximate, and I understand you don't have a date, but I'm asking time frame for the loan that you're talking about.
2000.
And you don't have to. I'm asking you to perjure yourself. Again, pre-divorce, post-divorce would answer my question.
No, it was before. I mean, it was during. It was before we actually went to court.
Okay.
And
Your
I tried
Honor,
to maintain. And I tried to maintain. I tried to help.
I can't hear of you because you're both talking over each other. My next question is.
Your Honor, if I could ask you to rule on my objection.
What did you? I couldn't hear it.
I said lack of authentication. Objection, Your Honor.
I don't know what you're objecting to. What are you objecting to?
This supposed loan, Your Honor.
Oh, I'm overruling that. I'm asking questions about it to learn more about it, sir. So I'm overruling your objection about that. Ma'am, are there any documents?
I'm gonna find a piece of paper with your handwriting on it.
Ma'am, that's not appropriate. You're not supposed to be having a conversation with Mr. Vu. So please stop doing that. Okay, I was asking a question before you interrupted me, Ms. Johnson. Do you have any documents regarding the loan?
Not with me, ma'am. I'd have to find it.
Do they exist?
It exists. Oh, it exists, but we're still under construction. I mean, it's in a box. I'd have to find it.
Okay. Was the loan addressed in your divorce?
No.
Do you know what he was supposed to pay towards you said that it was what he could afford.
He had several things going on at once. He had Cafe Madrid. He had.
Your Honor, again, objection relevancy.
And what's the relevance of that?
Your Honor, the issue before you is.
I was asking her. I was asking her why it's relevant, sir, not you why it's irrelevant. Ma'am, why is that relevant?
It's relevant because I think that he thinks that by giving me $900, that he's applying it to the child support, which we never agreed on. And where did that amount come from?
Okay, what does Cafe Madrid have to do with any of this?
Oh, it's yet another asset that he was trying to hide from me.
Okay, I'm going
On the
to
court.
sustain his
And
objection.
I didn't know about it.
Ma'am, I'm going to sustain his objection. Okay. Does anyone have anything further?
Just a quick, brief closing, Judge.
Okay, Ms. Johnson, do you have anything further? Any further
I would
evidence
like
you'd
to-
wish to present?
I would like the court to honor what was on the divorce decree. I mean, it was his lawyer and he that drew up the amount. And it was he that said that he was going to honor it, and he did not. Everything that's on that the divorce decree, he has not honored, and that's why I'm bringing up the beach house and the restaurant, and this because it's a history, it's a pattern. It's a pattern. Ask him about what happened to the restaurant.
Your Honor, again, objection relevancy.
Ask him what happened to the beach house. I
And
didn't have
objection,
insight
Your
in
Honor,
any of that
outside the
stuff.
scope of this proceeding.
I'm going to sustain both objections. You're back on the record. Okay, I've looked at everything and reviewed everything.
And Judge, if I may, I was gonna do a brief closing for the court, but
Okay, I'm
if
sorry.
it's okay, but if Your Honor already made a ruling or is about to pronounce a ruling, the only thing the state would be requesting in addition to the confirmation of the arrears is the allocation of the court costs associated to the filing of the MRED, and that's it. But I can do my closing if Your Honor wants to
No,
hear it.
no, it's not necessary.
Okay, perfect.
So I am going to give possession credits in the amount of $30,820.79. And that is the full amount less the full amount per exhibit. I'm sorry. Per exhibit E, which is her proposed periods of possession less that last column. And then I am going to also give some credit for direct payments and order a cumulative child support judgment against Mr. Vu in the amount of $75,000 as of, I guess, March 20th of 2024.
Yes, Judge.
In terms of a payout, I don't believe I ever heard how much is in the retirement account or how much approximately.
Yes, Judge, for this amount, for a judgment of $75,000, Judge, the arrears alone is 375. I'm sorry, the interest.
Yeah.
I'm sorry. Yes, the interest alone is $375 per month. State is just requesting that it cover the interest and an additional amount, so that it can cover that.
He was currently paying twice a month. It's just twice a month, $359.23.
Yes, Judge. It's about $718.46.
Why don't we set the payout then at $700 a month?
Yes, Your Honor.
I'm sorry, Your Honor, my dog was, I didn't hear that last amount about.
I'm sorry, I couldn't hear you.
Yeah, yes, I can, I
sorry.
can, man. You can't hear me.
No.
One more time, can you hear me?
Yes, but sometimes it breaks up, so I don't know if it's going to break up again until you start
Okay.
speaking.
Okay, I'm sorry, I didn't understand the $700 amount that you were talking about.
It's a monthly amount you're going to pay off that judgment.
Okay,
And then it will change though, because, well, it won't change, but it will go down faster because the Quadro is going to be entered. I have no idea how much is in that account. So I don't know if it's going to pay it in full, and once it's paid, you won't owe that anymore, or if there's going to be money left over. I don't know.
okay,
Correct.
so can I ask a process question? So the Quadro will sweep the account for $75,000. Is that what that means?
I don't know what's in the account, so I don't know I don't know how much money is in the account, so I can't. If there's only $5 in the account, it's not going to take 75,000, and I don't know the number. I don't think it's 5, but I don't know if it's 75,000 either.
Yeah, but if there is that amount, then what is the $700 a month for?
Because if there is only $5 in the account, you're going to have to pay this back.
I understand. Okay.
So it's
Thank
not going to take. It's all the state can take from you not really taking from you, all that they can withhold or that you will owe, because it might not, you might have to voluntarily pay this depending upon your job. All you would owe would be to pay off the 75,000 plus any interest that accrues on it, because it will accrue interest for the family code, 6% per annum.
Yes, Judge.
And that 700 will begin April 1st of 2024. And as I said, the judgment is as of March 20th. And then I'm going to order that Mr. Vu pay any court costs due to Galveston County for the motion to confirm arrears by September 30th.
How much is the court? I'm sorry. How much is the court cost?
I don't have an exact number for you, sir. It's usually a few $100s. Just depends on the filing fee and service fees and what service did or didn't happen in the case. So.
Yes, ma'am.
And Judge, you said September 30th of 2024, correct?
Yes.
Thank you, Your Honor.
And how will I be notified of that cost?
You should probably contact the district clerk's office in Galveston.
May I appeal this?
Yes, you may, ma'am.
I'm appealing it.
Okay, that you might want to consult a lawyer or the law library or texaslawhelp.com.
No, I will get a lawyer. I'm letting Doug know.
Ma'am,
I'm
saying it on the record, I just want this clear on the record. Saying you appeal it on the record does not appeal it. I just want you to know that. So you might want to consult a lawyer.
Thank you, Your Honor. And with that, Your Honor, may the parties be excused to the breakout room so they can prepare a final order on this case.
Yes, you all may be excused to the breakout rooms. The AG's office is going to draft the order. It is a ruling of me, so if you refuse to sign, I will be signing it anyway. One moment, ma'am. And yes, so in case you didn't hear that, you're going to go to the breakout rooms. Miss Villarreal is going to draft the order. She'll send it to you through DocuSign to review and sign off on. If you refuse to sign, that's fine. Signing it doesn't mean you agree, just so you know that. If you refuse to sign, that's fine, because it was a ruling of the court. I will sign the order. Ms. Johnson, are you okay?